In 1954, in Brown v. Board of Education, Chief Justice Earl Warren declared for a unanimous Supreme Court that racial segregation violated the 14th Amendment's Equal Protection Clause. Just as Dred Scott had long been considered the low point of judicial interpretation of the Constitution, Brown has long been considered a high point. And in 1974, in United States v. Nixon, Chief Justice Warren E. Burger ruled for a unanimous Supreme Court that President Richard Nixon had to obey a federal court's order to turn over tape recordings of private meetings with key aides as evidence in the Watergate investigations. This decision, upholding the principle of the rule of law against a sweeping claim of presidential authority, helped to force Nixon to resign his office. Third, customs and usages grow up around the Constitution, helping to guide its day-to-day workings. Political parties are not mentioned in the Constitution, but they have become essential to the workings of the elected branches of government and to the conduct of elections. Our founders were not keen on political parties. They weren't keen on the idea of... They definitely weren't keen on the idea of a two-party system, and they weren't keen on the idea of political parties taking over as opposed to individual citizens making decisions for themselves. So too, federal courts recognize, quote, executive privilege, end quote, the principle that a president's confidential discussions with his aides should stay confidential in most circumstances, but not, as in United States v. Nixon, when records of those discussions may be essential to investigate alleged crimes. These three forms of constitutional change work together in a complex series of interactions, but they all help to maintain the American constitutional system's ability to respond to new circumstances and conditions. R.B. Bernstein, Adjunct Professor of Law, New York Law School, 2002. I'm going to break this up, but, excuse me, I'm going to go ahead and read the chronology because it's not long enough to be its own thing, but it's the last thing before the actual Constitution starts. So just for anyone who wants to know these facts. Chronology. September 5th through October 26th, 1774. First Continental Congress meets at Carpenter's Hall in Philadelphia to coordinate American resistance to British colonial policy. April 19th, 1775. Battles of Lexington and Concord in Massachusetts mark beginning of American War of Independence. May 15, 1776. Second Continental Congress instructs states to adopt new constitutions of government. July 2nd through 4th, 1776. Second Continental Congress declares American independence and adopts Declaration of Independence. September 3rd, 1783. Signing of Treaty of Paris, under which Britain recognized American independence and ceded territory between Allegheny Mountains and the Mississippi River to United States. May 25th, 1787. Federal Convention convenes in Philadelphia in Assembly Room of Pennsylvania State House, Independence Hall. July 13th, 1787. Confederation Congress, meeting in New York City, adopts Northwest Ordinance. September 17, 1787, Federal Convention adopts final text of proposed Constitution and dissolves. June 21st, 1788, New Hampshire's ratifying convention adopts proposed Constitution, 89 through 79, becoming the needed ninth state, putting the Constitution into effect as the form of government of the United States. April 30th, 1789, George Washington inaugurated as the first president of the United States at Federal Hall in New York City. December 15th, 1791, Virginia ratifies 10 proposed constitutional amendments, adding the Bill of Rights to the U.S. Constitution. March 4th, 1801, Thomas Jefferson inaugurated as third president of the United States in Washington, D.C., marking the first presidential inauguration in the nation's permanent capital. February 24th, 1803, Chief Justice John Marshall hands down the unanimous decision of the U.S. Supreme Court in Marbury v. Madison, establishing the doctrine of judicial review on federal statutes. March 16, 1810, Chief Justice John Marshall hands down the decision of the U.S. Supreme Court in Fletcher v. Peck, establishing the doctrine of judicial review of state legislation under the Supremacy Clause of the Constitution. March 6, 1857, Chief Justice Roger B. Taney hands down his opinion for the court in Dred Scott v. Sanford, declaring that the federal government has no power to restrict the spread of slavery within the United States or its territories. April 12, 1861. Again, the outcry over that decision was mainly that while some wanted that power, wanted to be able to spread slavery, others did not want it to spread. And so when they pass this decision that says the government can't stop it, people were upset, right? People were upset. And that's what started the war, is because there were so many people who did not want slavery spreading into their territory, and there were people who wanted to be able to expand slavery. Like, in our minds, we think it's because they were told they couldn't, and then they wanted to fight about it. They were told they could, and other people wanted to fight against it. April 12, 1861, beginning of Civil War with surrender of Fort Sumter in Charleston, South Carolina, to forces of Confederate States of America. January 1st, 1863, President Abraham Lincoln issues final Emancipation Proclamation declaring all slaves in states rebelling against the Union, quote, forever free, end quote. November 19th, 1863, President Abraham Lincoln delivers Gettysburg Address. December 6, 1865, ratification of the 13th Amendment, proposed January 18, 1865, outlawing slavery in the United States. July 9, 1868, ratification of 14th Amendment, proposed June 13, 1866, establishing equal protection of the law, supremacy of federal citizenship, and requiring states to follow due process of law. It's funny because, they don't necessarily mention in here, I guess, the specific time frame of when the last slaves were freed, which is why we celebrate Juneteenth, right? Those of you that do celebrate, those who recognize that. But the 14th Amendment was actually proposed on June 13th, 1866. So either way, Juneteenth, that's something that sticks out to me. February 3rd, 1870, ratification of 15th Amendment, proposed February 26, 1869, forbidding discrimination in access to the polls on the basis of race, color, or previous condition of servitude. May 18, 1896, U.S. Supreme Court decides Plessy v. Ferguson, upholding, quote, separate but equal, end quote, principle, and thus allowing state laws requiring segregation of the races. Terrible decision. August 18, 1920, ratification of 19th Amendment, proposed June 4th, 1919, forbidding discrimination in access to the polls on the basis of sex. Again, women did not get the right to vote, no matter what color they were, until 1920. So that means that men of any color had the right to vote long before women. April 12, 1937, U.S. Supreme Court decides the National Labor Relations Board v. Jones and Laughlin Steel Corporation, upholding federal power to regulate labor relations. May 17th, 1954, U.S. Supreme Court decides Brown v. Board of Education, striking down school segregation as violation of 14th Amendment's, quote, equal protection, end quote, clause. March 9th, 1964, U.S. Supreme Court decides New York Times Company v. Sullivan, imposing federal constitutional standards on libel suits brought by government officials against the news media. I need to study that one because I don't personally think that that government officials should be able to sue the news media if it's speaking truth about them. I mean, I don't agree with targeted attacks that are arbitrary and with nefarious intent, but we cannot silence journalists speaking truth to power, otherwise we end up with tyranny. July 2nd, 1964, enactment of U.S. Civil Rights Act of 1964, upholding sweeping federal authority to enforce civil rights against state and local governments and to bar private discrimination. June 7th, 1965, U.S. Supreme Court decides Griswold v. Connecticut, recognizing constitutional protection for right of privacy in decisions about giving birth and using contraception. Let me read that one again. June 7th, 1965, U.S. Supreme Court decides Griswold v. Connecticut, recognizing constitutional protection for right of privacy in decisions about giving birth and using contraception. June 13th. Seems to be a popular date. 1966, U.S. Supreme Court decides Miranda v. Arizona, enforcing federal constitutional protection of rights of criminal suspects and defendants against state and local governments, origin of the, quote, Miranda warnings. June 30th, 1971, U.S. Supreme Court decides New York Times v. United States, the, quote, Pentagon Papers case, rejecting the idea that federal government can invoke national security as justification to prevent publication of news stories. That's a really important one, so let's read that one again, too. June 30th, 1971, U.S. Supreme Court decides New York Times v. United States, the Pentagon Papers case, rejecting the idea that federal government can invoke national security as justification to prevent publication of news stories. How many news stories have been prevented from being published since 1971, supposedly in the interest of national security? Why are we allowing our government to violate our constitutional rights on a regular basis? I don't understand this. January 22nd, 1973, U.S. Supreme Court decides Roe v. Wade, upholding federal constitutional protection for a woman's right to decide whether or not to have an abortion. July 24th, 1974, U.S. Supreme Court decides United States v. Nixon, rejecting sweeping presidential claims of executive privilege and holding that a president must submit to a federal grand jury's demand for evidence in an ongoing investigation. If you're not breaking the law, you shouldn't have a problem with these laws. Only criminals want laws to protect criminal behavior. June 26, 1978, U.S. Supreme Court decides Regents of the University of California v. Bakke, recognizing the constitutionality of, quote, affirmative action, end quote, programs. Those types of programs might be necessary for a certain amount of time to rebalance scales, to help people who have been disenfranchised sort of catch up. But over time, those laws can be used to create the opposite effect. So for anyone who knows, who follows me and like pores over every word I say, and sometimes it seems like I contradict myself. I understand that. Thing is, I see both sides of the coin. Anything good can be used for bad, and anything bad can be used for good. Okay? We shouldn't not have good things just because they might be used for bad, but once we see that they are being used for bad, we need to take a step back and say, hey, how can we, what's a better way to solve this issue? Before we allow it to basically just flip-flop so that now we have the same issue but from the opposite perspective. Because that's not helping. Excuse me. June 29th, 1992. U.S. Supreme Court decides Planned Parenthood v. Casey upholding constitutional protection of women's right of choice. December 12th, 2000. U.S. Supreme Court decides Bush v. Gore resolving disputed 2000 presidential election. Justices rule 7-2 that proposed recount in Florida of disputed votes does not meet standards of, quote, equal protection of the laws, end quote, set forth in 14th Amendment, and further rule 5-4 that exigencies of deciding a presidential election rule out a further statewide recount. So keep in mind now that when the exact same thing happened in 2000, they argued against a recount. They decided that, nah, it's not we don't. And then you've come back around to 2020 and they're making the same argument for the other side. So the exact same thing they did not want to allow for one party, they then turned around and attempted to argue for their own. This is why we cannot live under this duopoly, which is really not even a duopoly, it's a monopoly, and they're using these two arms of political parties to just basically bat us all back and forth like a cat with a ball of yarn. It's very sad and very disgusting. Anyway, that's the end of that, and the next page starts the Constitution of the United States, but it's been over an hour and I'm tired of talking right now, so I'm going to come back and start that later. You guys have a blessed day. Thank you for paying attention, if you have, to this point.